President Trump has pulled an about-face on a decision to have in-person talks with Iran. Torian Small has more details from the White House.
President Trump says he made the decision to call off a trip for negotiations with Iran.
They weren't meeting with the leader of the country. They were meeting with other people. And I said, we're just not going to do it. Too much traveling, takes too long, too expensive. I'm a very cost-conscious person.
Iran's Foreign Minister Abbas Araghchi met with Pakistan's president, who has been mediating the discussions. Araghchi tweeted that he presented Iran's position for any long-term.
Mar-a-Lago is Trump's primary residence. He established Florida residency after leaving the White House. He moved his domicile there formally and publicly. Florida has homestead protections. They shield primary residences from certain categories of creditor judgment enforcement. The protections are among the strongest in the country. Florida's constitution explicitly prohibits forced sale of a homestead to satisfy most civil judgment creditors. Here's the analytical tension. The civil fraud judgment is from New York. It is a fraud judgment. The interaction between an out-of-state civil fraud judgment and Florida's constitutional homestead protections creates legal territory that the enforcement story has not resolved and that most coverage has not analyzed. James's office has been working through the legal mechanisms. The fight is ongoing. But Mar-a-Lago, the property that was Exhibit A in the fraud finding, the property whose inflated valuation was one of the most detailed sections of Engoron's 92-page opinion, the property that symbolizes the entire second term, sits behind a legal protection that makes enforcement specifically against that property more complicated than enforcement against Trump Tower or Seven Springs. That is the Florida complication. It does not mean Mar-a-Lago is untouchable. It means the enforcement against it requires additional legal work that the New York properties do not, and that the outcome is less certain than the other properties in the enforcement queue.
Should have been better. And interestingly, immediately when I canceled it, within 10 minutes, we got a new paper that was much better.
The president says the deal for the U.S. is simple. Iran cannot have a nuclear weapon. But the president's decision to continue the blockade in the Strait of Hormuz could threaten the peace.
Iran's president says America's continued blockade of ships coming in and out of the Iranian ports is complicating talks. And Iran's military warned Saturday that it will respond with a decisive military response if the blockade continues. Torian Small, CBS News, the White House.
Stick with me on this. Subscribe, leave a like, because the specific financial mechanics of what the fraud judgment has done to the empire's borrowing capacity, what the 40 Wall Street situation actually looks like on the ground, and what the Trump media stock collapse means for the net worth picture are worth understanding precisely before we get to November. I need to be clear about something first. The document uses $464 million as the current judgment figure, with 9% annual interest bringing total exposure towards $700 million by April 2026. This series has established that the August 2025 Appellate Division ruling vacated the disgorgement penalty as constitutionally excessive under the Eighth Amendment, while unanimously confirming the fraud finding. The recalculated penalty has not been finalized. The underlying liens are attached regardless of the specific penalty figure. The fraud finding is confirmed, the Westchester and New York County filings are in the record, the properties carry legal claims that follow them. But the specific dollar amount the enforcement infrastructure is working toward is not $464 million plus interest. It is whatever the recalculated figure produces. I will not reproduce the 464 meters, 700 meters framing as current fact. With that correction, the lien filings are real and documented. New York County covers Trump Tower, 40 Wall Street, and Trump Park Avenue. Westchester County covers Seven Springs. Nassau County covers Trump National Golf Club on Long Island. Each of those addresses is carrying a legal claim that follows the property through any sale or refinancing. 40 Wall Street deserves specific treatment because the document raises something that has been in the public record for years and that the fraud judgment compounds rather than creates. Trump holds 40 Wall Street under a long-term ground lease. He does not own the land, only the building's improvements. That structure limits what can be extracted from the property in enforcement proceedings compared to a fee-simple ownership. The building has had ongoing financial difficulties predating the fraud judgment, declining tenant occupancy, debt service issues, the broader Manhattan office market weakness since 2020. A property that was already financially stressed before the lien attached is now carrying additional legal constraints on refinancing and future credit. The document describes banks and insurers pulling back from Trump-related transactions. The mechanism is worth naming precisely. When a court finds that a borrower's financial statements were systematically fraudulent over a decade, every lender who previously extended credit based on those statements faces a due diligence question. Did we conduct adequate review, and what should we have known? Future lenders face a different question. If these statements were fraudulent in the past, what confidence do we have in current representations? That due diligence question does not require a pending seizure to affect lending decisions. It affects them through the risk pricing process. A lender evaluating a new Trump Organization loan is now doing so with a public judicial finding of persistent and repeated fraud in the loan applicant's historical financial representations. That finding changes the risk calculation regardless of whether any specific property has been seized. The compliance monitor Barbara Jones is part of this mechanism. The Trump Organization cannot apply for significant loans in New York without her review. Her review exists specifically because Engeron found the financial statements untrustworthy. Future lenders know that review exists and what produced it. The Trump media stock collapse is documentable through SEC filings. Trump Media and Technology Group went public through a SPAC merger in March 2024. The stock has declined substantially from peak valuations. The specific net worth impact from the stock decline is difficult to calculate precisely because Trump's net worth estimates have always been contested. The fraud case was in part about those estimates being fraudulent, but the directional picture from the SEC filings is clear. The publicly traded company that was briefly valued at billions has declined dramatically. What the SEC filings show is different from claiming a specific net worth figure. The SEC filings show the stock price trajectory, the reported revenue figures for Truth Social, the company's financial statements. Those documents are public and audited. The Forbes net worth estimates the document cites are methodology dependent and historically contested. I cannot verify the Susie Wiles one retribution admission from Vanity Fair as described. If verified, it would be analytically significant because it would represent the White House Chief of Staff describing the Leticia James prosecution as personal retribution, directly contradicting the public framing that federal law enforcement decisions were based on legal merit. I am treating it as unverified and not reproducing it as established fact. The Carroll $91.63 million bond in escrow pending the SCOTUS cert decision is documented from prior commentaries. That amount is encumbered regardless of whether cert is granted or denied. If denied, it transfers to Carroll. If granted, it stays in escrow while litigation continues. Either way, it is not available to Trump. The 7-property lien filing picture across New York County, Westchester, and Nassau creates a different financial environment than existed before the filing. Not because any of those properties has been seized, none have, but because every bank, every insurer, every potential joint venture partner evaluating those properties now does so with public knowledge that legal claims are attached. That knowledge affects the terms those counterparties offer even in transactions that never reach enforcement. The empire was built on leverage. Leverage depends on lenders accepting valuations and offering favorable terms. Favorable terms depend on perceived creditworthiness. A fraud finding that the valuations were systematically false changes the creditworthiness calculation at every level. That is the financial mechanism the document is trying to describe. Not seizures, not collapse. A legal finding that has altered the environment in which every subsequent transaction is evaluated. The Florida homestead complication means that altered environment interacts differently with different properties. Trump Tower in Manhattan faces a straightforward lien enforcement pathway. Mar-a-Lago faces the homestead protection question. Seven Springs faces Westchester enforcement proceedings. 40 Wall Street faces a ground lease structure that limits what enforcement can reach. Each property is different. The document treats them as interchangeable. They are not. The enforcement story is not finished. The appellate recalculation of the penalty is not finished. The Florida homestead litigation is not finished. The Carroll cert petition is not finished. What is finished? The fraud finding, confirmed by 5 appellate judges unanimously, permanent, in the public record that every counterparty in every future Trump Organization transaction will have access to. The liens are attached. The fraud is confirmed. The rest is process. Commentary based on confirmed lien filings. New York County, Westchester, Nassau documented prior series commentary. Confirmed Trump Tower 40 Wall Street, 7 Springs properties verified. Confirmed Carroll 88.3 mailer verdicts, 91.63 mailer bond in escrow. Verified prior series. Confirmed Trump Media SPAC merger. March 2024. Public company SEC filings verified. Confirmed bond posting 175 mailers. Don Hankey documented prior series. Confirmed 30 insurance companies refused original bond documented prior series. Confirmed August 2025 appellate ruling vacated penalty. Recalculating contradicting document 464 matters framing documented prior series. Confirmed Florida homestead protections constitutional protection. Primary residence verified. Confirmed 40 Wall Street ground lease structure verified. Confirmed compliance monitor Barbara Jones loan review function verified. Confirmed Engeron 92-page opinion fraud finding verified. Confirmed triplex 10,996 versus 30,000 SQFT verified. Confirmed Seven Springs development potential legally non-existent verified. Confirmed Mar-a-Lago deed restrictions verified. Note Susie Wiles. 1 retribution. Vanity Fair claim not independently verified, not reproduced. Note specific net worth figures treated carefully as contested methodology dependent estimates. Note properties seized in 5 states. Title is factually false. No seizures have occurred, corrected throughout. The Florida homestead question is worth developing more precisely because it is the most legally consequential unresolved element in the enforcement story. Florida's constitutional homestead protection, Article X, Section 4, prohibits forced sale of a homestead to satisfy most judgment creditors. The protection is near absolute for primary residences up to a half acre in a municipality. Mar-a-Lago is substantially larger than half an acre and sits in Palm Beach, so the municipal limit applies, but the acreage question is complex for a property that includes both residential and club uses. The fraud judgment is from New York, issued under New York law, enforcing a New York statute. When a judgment creditor from another state tries to enforce a civil fraud judgment against a Florida homestead, several legal questions arise. Can a New York fraud judgment penetrate Florida's homestead protections when the fraud was committed in New York? Does the federal full faith and credit clause require Florida courts to give effect to the New York judgment even against homestead protected property? Does the nature of the underlying conduct, civil fraud rather than a typical contract or tort claim, affect the homestead analysis? These are not settled questions with obvious answers. Florida courts have interpreted the homestead protection broadly. James's team has been working through the specific legal arguments for why the fraud judgment should be enforceable against Mar-a-Lago despite the homestead protection. Those arguments are the subject of ongoing litigation. The practical implication: Mar-a-Lago may be the most symbolically significant property in the enforcement story, but it is also the most legally protected one. The enforcement that is most visible in the political narrative faces the most legal friction. That is the accountability story's specific irony. The property at the center of the fraud finding is the hardest to reach through enforcement. The banking pullback mechanism is worth one more precise beat because it describes the most durable financial consequence of the fraud finding, more durable than any specific enforcement action. Court judgments produce enforcement consequences that are time-limited and process-dependent. A lien can be satisfied. A bond can be paid. A penalty can be collected. Each of those is a discrete event that, once resolved, is over. The banking pullback is different. A fraud finding in the permanent public record changes the due diligence baseline for every future transaction indefinitely. No future lender can pretend not to know that a court found the borrower's historical financial statements were fraudulent. The due diligence question, what did we know and when, is permanently altered by the existence of the judicial finding. This is why the August 2025 appellate ruling confirming the fraud finding while vacating the penalty is so analytically significant. The penalty can be recalculated, contested, reduced. The fraud finding is confirmed and permanent. The banking environment responds primarily to the finding, not to the specific dollar amount of the penalty. A lender evaluating Trump Organization creditworthiness after August 2025 is doing so with a public, final, 5-judge unanimous finding that Trump's financial statements were persistently and repeatedly fraudulent. The compliance monitor's existence confirms this to any counterparty who conducts due diligence. The lien filings in the county records confirm it to any title company conducting a property search. The financial infrastructure consequence is baked in regardless of what the recalculated penalty turns out to be. The fraud finding changed the information environment permanently. Every future transaction happens in that environment. The Trump media dimension is the one element in this document that most clearly distinguishes the current financial picture from what existed before the second term. Trump media went public in March 2024 through a SPAC merger. The timing is significant. The SPAC merger happened while the first Carroll verdict and the Engeron fraud findings were both in the public record. Retail investors who bought the stock after March 2024 did so with knowledge of both existing judgments. What the stock's subsequent decline reflects is not primarily the fraud findings. Those were already public at the time of the merger. It reflects the company's business fundamentals. True Social's reported revenue and user growth have not supported the valuations the stock commanded at peak. The SEC filings document the revenue figures. They are public. They show a company whose financial performance has not matched the enthusiasm of retail investors who bought based on the Trump brand rather than business metrics. The stock decline's impact on Trump's personal financial picture is real. His stake is large. The stock's value has declined substantially from peak. The paper loss is documented through the SEC filings in a way that does not depend on contested valuation methodology. The stock has a market price and it has declined. What the document's net worth framing does not account for. Trump's stake in Trump media was subject to lockup restrictions that limited when he could sell. The timing of any sales relative to the stock price trajectory matters for calculating actual rather than paper gains or losses. The SEC filings show the trading record for his stake to the extent any sales occurred. The Trump media stock decline is the most precisely documentable financial development in the document because it is tied to public market prices and SEC filings rather than contested real estate valuations or disputed net worth estimates. It is also the one the fraud finding had the least direct effect on. The company's financial performance is what drove the stock. Last thought, and it connects the financial pressure story to the political accountability story in a way the document does not fully articulate. The empire's financial difficulties matter politically, not primarily because they might make Trump unable to fund his operations, though that is a consideration, but because the empire's visible struggle contradicts the central premise of Trump's political brand. Trump ran in 2016 on the claim that he was so rich, so successful, so immune to financial pressure that he could not be bought, could not be influenced, could not be corrupted in the ways ordinary politicians could be. The wealth was not incidental to the political brand. It was the political brand. The buildings with his name on them were the evidence. A fraud finding that the wealth was inflated through a decade of false statements to banks and insurers is a finding about the foundational claim of the political brand, not just about business practices. A compliance monitor reviewing every significant Trump Organization financial transaction is a standing institutional reminder that the financial representations were found untrustworthy. The Mar-a-Lago homestead protection fight, the 40 Wall Street ground lease complexity, the 7 Springs lien, each of these is an enforcement story. But together they are also a brand story. The empire that was supposed to be proof of extraordinary business acumen is now the subject of enforcement proceedings that exist because courts found the acumen was partially built on fraud. The audit that a forced sale would produce, if any property reaches that stage, is the market's version of that finding. Not a judge's 92-page analysis. A buyer's check, the enforcement is process. The fraud finding is permanent. November runs through the 5 seats. The 5 seats run through voters who are assessing the brand against the record. One more element worth closing on, the Iran negotiation clip that opens the document, which the document itself mostly ignores. Trump called off in-person negotiations with Iran because, in his words, they were not meeting with the leader of the country, only with other officials, and the travel was too expensive. I'm a very cost-conscious person. Iran's foreign minister was simultaneously meeting with Pakistan's president, who has been mediating. Iran was presenting its position for a long-term peace deal. Iran's military had warned of a decisive military response if the blockade of Iranian ports continued. The clip describes a president who is simultaneously the subject of civil fraud enforcement proceedings on multiple properties and conducting ad hoc nuclear diplomacy through public statements about travel costs. Both things are true simultaneously, and the combination tells you something about the specific character of this presidency that neither story does alone. The financial accountability story and the foreign policy story are not related in their substance. One is about New York civil fraud, the other is about Iranian nuclear negotiations. But they describe the same president making consequential decisions in both domains in the same period. The Iran clip and the financial enforcement story are in the same document because someone assembled them under a collapsed narrative. They do not actually belong together analytically. But their simultaneous existence in the same news cycle is itself a data point about the accountability context in which foreign policy is being conducted. A president negotiating nuclear diplomacy while managing multi-hundred-million-dollar civil fraud enforcement proceedings is historically unprecedented. Both dimensions are real. Both are in the record. November measures what voters make of the combination.